Hello, welcome everyone. Thank you all for joining. This is Legal Funding Journal's virtual town hall spotlight on the Middle East. I am your host, John Freund, managing editor of Legal Funding Journal. I'm a bit under the weather, so I apologize if you hear some coughing sounds from me. But I do want to thank you for joining us. We've got a really wonderful panel today. We got a very timely topic that doesn't get enough coverage, so we're really excited about this. And we've got a lot to cover, so I'm just going to get right into it. A few very brief housekeeping points to start. First off, all registrants will receive a link to a recording of this event via email, so please stay tuned for that email post-event. Also, the format of today's event, it will include a panel discussion followed by a Q&A with you, the attendees. So there's two ways to submit questions. We encourage you to submit your questions throughout the event. There's two ways to do that. One is you can use the comments feature there on LinkedIn, or you can submit questions via email to me. That's John, John, at legalfundingjournal.com. John at legalfundingjournal.com. You can submit those questions throughout the event, and we'll get to as many as we can, time permitting. So please do that. Also, we will be hosting virtual town halls on a monthly basis going forward. So we're going to be covering lots of themes and different topics that are important to our community. And we really encourage you to suggest any topics of interest, anything you'd like to hear, learn more about, and even if you'd like to participate in. We'd love to hear more from you, our audience. Lastly, Legal Funding Journal is the most comprehensive source of news and events taking place in the legal funding sector. Members rely on LFJ to stay on top of case developments, funding activities, regulatory updates, and people moves, as well as to gain access to original content produced by some of the leading thought leaders in the industry. So if you'd like details on becoming a Legal Funding Journal member, you can visit us at www.legalfundingjournal.com. With that, I'm going to introduce the moderator of today's event, Jonathan Davidson. Jonathan is a dispute resolution lawyer and founding partner at Davidson & Co. He has 25 years dispute resolution experience and has acted in all manner of disputes for institutions, developers, investors, and public companies, as well as for private companies and individuals. Jonathan first arrived in Dubai in March of 1999, and prior to founding Davidson & Co. in October of 2008, worked at Clyde & Co., where he was a legal director, and lately he was a legal director at Dubai Holding. Jonathan is an experienced litigator, and over the past few years, he's played a key role in the evolving role of funding in the Middle East legal landscape. So, Jonathan, with that, I'll turn it over to you.
Thank you, John. That's very kind. I think we have a very international audience and a very international panel today. So welcome to the live Legal Funding Journal Town Hall. The Middle East is one of the fastest growing emerging markets in the global legal funding sector. And our panel today, all of whom are based in the Middle East, will be exploring the nuances, the challenges, the opportunities of legal funding in the Middle East. So it's my pleasure to present our panel from today. Kishore Jayachandani. Kishore is founder and managing director of Caveat Capital and an expert in litigation funding globally. His expertise includes developing financial solutions to help law firms and big corporations to mitigate risk and achieve their growth strategies, including litigation portfolios as collateral for off-balance working sheet capital and monetization litigation and judgments. Kishore can draw upon his company secretarial and his MBA finance background to do innovative structural engineering using litigation finance as the backing asset. Ahmed Hamadi, welcome Ahmed, is legal director in the disputes team of global law firm DLA Piper. He's based in Dubai. He's been working in the region for over a decade, and during that time has worked on finance, corporate, and litigation matters. He has broad disputes experience in the region and regularly advises clients for disputes before the onshore courts in the region, which tend to predominantly or exclusively be in Arabic, and the offshore courts in the region, which tend to be in English. And finally, Nick Rolls-Davis. Nick has been involved in the litigation, finance, and legal expenses insurance industry since 1999. Since 2010, he's held senior executive positions in several global litigation funders, both privately held and publicly listed. He's a former director of the Association of Litigation Funders of England and Wales. Nick is the author of Third-Party Litigation Funding, published by Oxford University Press in 2014. He's also a contributing author to the Legal Risk Management Handbook and Friston on Costs. So there is our panel. We can dig straight into it. Now, my initial observation is that the Middle East has been absorbing litigation funding as an investor asset and as a mechanism for access to justice and access to corporate liquidity for, I think, 5 or 6 years predominantly. Although, Nick, I know that you have been involved in the industry here for longer than that, and you have been involved in some fairly front-running cases. Could you tell us a little bit about your experience over here?
Yeah, thanks, Jonathan. I've been lucky enough to be funding here for about 15 years. I think the first case I was involved in was back in 2010-11, a DIFC case. I think it was the first funded DIFC case called Carafian Bank Saracen. That was a bit of a front runner. It was a one-off, interesting case and luckily a successful one. And I think the first types of cases we saw from 2010 onwards were mainly DIFC, less so, certainly no local court cases, and less so of what we now see, which is a sort of growing interest and from about 2015 onwards, a serious interest in construction arbitration, whether it be what was DIFC, LCIA, or now DIAC. And that's a very much a thriving part of litigation finance in this region, particularly Dubai. And historically, I think it's fair to say DIFC was where it started. They were single cases. But then as sort of 2016, 17 onwards, and certainly now, the construction sector embraced litigation finance where there was a sort of liquidity issue, and portfolio financing of claims and defenses on a portfolio basis, really where I think the region took off in litigation funding. And certainly that's been my experience.
Okay, Ahmed, interesting to me is that your practice covers the Arabic civil law side and also the common law side. And we've got a bit of feedback, I think, on one end. Let's work through that. John, tell me if that affects the broadcast. Yeah, I mean, I think actually the feedback's on you. So let's see if we can get to this question. So your practice straddles both the Arabic civil law and the common law. Now, historically, as Nick touched upon, cases here, there's very large scale, huge value construction and engineering cases. Do you find those predominantly to be the fundable cases, or are we looking at general commercial litigation, shareholder disputes? Is there more of an even spread?
Thanks, Jonathan. I think it's worth also picking up on Nick's point. I think there are two, as I would describe them, comfort zones as we see them now. And the two comfort zones are generally banking and construction. The banking, as Nick says, goes back a while, back to 2014 when you had the DIFC case of Saracen, which I think even prompted the DIFC to seriously consider putting litigation funding into its practice directions in 2017. So big deal that. But I'd say those are the comfort zones for a few reasons. And the principal ones are their core industries and sectors in this region and not just in the UAE. I mean, even as a disputes lawyer, I think you might agree, Jonathan, that construction touches all of our lives in one way or another, even if you try to avoid it. Yeah. But it's seriously interlinked. Secondly, these industries have customary documents, right? So with construction, you have FIDIC. Obviously, there are some employers that will have a little bit of a bespoke contract, but they are kind of coming out of the internationally accepted standards or norms. And similarly with banking, you have a lot of, in a sense, LMA documents. So you have concepts that are understood internationally, albeit you'll have some local flavor in their interpretation application. Interest, concurrent delay, how they deal with guarantees and that sort. But that kind of leads into the other point, which is connected, which is comfort and foreseeability in terms of outcomes, in terms of a lot of these issues, which, kind of drives, the investment in these two kind of sectors. Now, you have to take that with, I think, the availability of counsel that is established enough that can deal with these kinds of cases. And over time, the region has become full of the international firms and the local firms and the ones that can work together to kind of deliver the results that you need. And most importantly, I think with these two comfort zones is payment, right? I think especially on the construction side of things, you know who the big developers are, you know who the employers are, and you know who the big main contractors are. So we have claims going up the line. You can even, in a way, transparently understand what your payment is going to look like down the line and on enforcement. Doesn't come without its complications, obviously, especially in construction, because especially if the construction's financed, because then the funder has to think, if it's financed, who has entitlement to the receivables first coming out of the project. But overall, I would say those are why they are comfort zones.
Oh, that's interesting. Kishore, now that leads to, so we have large claims, we have banking, we have construction, and we have some general claims. We have claims that are being brought in the common law jurisdictions. The acronyms we use are ADGM and DIFC. As we know, that's the Dubai Financial Center and the Abu Dhabi Financial Center for those outside of the Middle East. Now, in terms of budgets, what's your experience in whether funders have to adopt the same level of budgeting here as elsewhere in the world, or whether there's a different approach? Are certain types of proceedings, maybe the onshore proceedings, are they leaner in terms of fees? What's your experience?
Well, thank you for introduction, Jonathan, and good question. I'm here in Dubai 27 years, and litigation funding is still growing into Middle East, not at par with the mature market like UK, US. In terms of budgets, legal budgets in Middle East are increasingly aligned with the global markets now, especially after the ADGM and DIFC. And especially for the complex litigation and arbitration, there are regional variations. Okay, so that still remain with the factor like jurisdiction, legal framework, market maturity. It depends where is the claim, like a Saudi, UAE, Qatar, Oman. So let's say for domestic dispute, budgets are comparatively lower. Okay.
Yeah.
So onshore litigation in Middle East jurisdiction like Saudi, Oman, Qatar, they are often having a lower cost in comparison to the Western jurisdiction like UK, US, Europe. This is due to the like a simplified court process, lower attorney fee here, and fewer procedural stages. Like, for example, we have seen a case which is having $5 million claim size in Riyadh. And the budget for that case was $250,000 as a legal fees. In contrast, if you see similar case in the US federal court system, that could exceed to $1 million.
Yeah.
And due to the reason like extensive discovery, disposition, trial stages. So now if we talk about this, like budget are like ADGM, DIFC, and like higher complex cases. So these jurisdiction, they are coming up with this almost at par with the international practice budgets. Okay.
Okay. Yeah. Yeah. No.
So
yeah. Sorry.
Like for example, I'll give you another case. Like DIFC, there's 150 million construction dispute case in DIFC, and the legal budget is 4.5 million, which is equal to somewhere LCIA, London Court of International Arbitration. And the major part is that witness.
That's cheap. Some lawyers, of course, might say that's cheap, Kishore.
Well, this is the situation in the Middle East. And you see Saudi Arabia, let's talk about Saudi Arabia. The market is like legal reforms are taking place there, and the cost of legal fund budget is increasing there also in Saudi from before. Okay, so we have seen a case $20 million in Riyadh, and it's $1.2 million is case budget. Okay. Yeah. And that's driven by the international law firm for the advisory role.
Yeah.
Okay.
Yeah.
So market is still growing. Now, when you talk about offshore versus onshore jurisdiction of the court, like we observe that the offshore court, like ADGM, DIFC, they are typically mirror the international market cost. Okay. Onshore, let's say UAE Federal Court, Saudi Board of Grievances, they are kind of cost effective.
Yeah, and that I do have a point on that. Ahmed, maybe you can help with this one. The civil proceedings has a different set of rules on costs, on adverse costs, on claimants' costs, defendants' costs, and the common law does. And I'm going to ask Nick in a minute how that affects the budgeting and the economics of quantum. But from your perspective, I guess if you're at a civil law proceedings, which here would tend to be the Arabic courts, there are no large adverse substantive costs awards, so therefore you don't need ATE insurance for adverse costs. How does that tend to affect the way claimants approach cases? Are they more gung-ho? Because A, Kishore said the costs are lower, and B, there's no adverse costs. So that makes it a claimant-friendly jurisdiction. Is that a fair thing to say?
I think that's a really fair thing to say as far as, claimant friendly is. And at least when we budget for costs, we budget for it on the basis of the entire proceeding. So we're looking at first instance appeal and cassation all the way through, because there's more than just cost consequences. There is no encouragement to settle disputes in a sense, because the without prejudice is also kind of developing, and you're not penalized, obviously, for running a claim that is, let's say, wholly unsuccessful in the end. So kind of at the outset, on the one side, preparing obviously your client mentally for the position, but the costs are assessed as a full engagement and in the entirety of the proceeding, because effectively you're going to go through an automatics appeals process.
Yeah. No, I get that. Nick, that leads on to my question to you. How do the economics work from a funder's perspective? So we have cases here. There's got to be a funder must have a minimum ticket to make the economics work. Does that change if you're in common law jurisdictions when you factor in costs that you will get back as the claimant, costs that you might have to pay as the defendant's costs if you lose as the claimant, vis-a-vis the civil proceedings where that might not factor in? So ticket size and how does the cost regulations impact on funders?
So the ticket size is not much. I mean, the basic principles of funding don't change whether you're in the GCC or whether you're in Europe. There are other considerations. So if you're in the local court, where I have to be honest, the exposure from most international funders in local court funding is in relation to enforcement of arbitral awards rather than funding disputes. A, because the budgets are, as we've discussed, tend to be a bit lower, and B, there isn't a massive appetite for international funders to fund in local courts. And also, of course, they're in Arabic, which tends to limit the number of funders that can actually operate there. So funders will be operating in the offshore jurisdictions, the IFC, ADGM, where there are cost shifting rules and there is adverse costs. Now, one of the challenges with that is there aren't a lot of ATE or insurance carriers that can write ATE insurance in the DIFC or ADGM. So you have to use indemnities from a funder backed off maybe in London or by an insurer that's happy to insure the funder in a different, in the UK jurisdiction. So it can be done, and it's something that we have to take account of. So it's there, and it's no different from any other cost shifting jurisdiction. In terms of the assessment of what you'll fund in relation to quantum, it's the same principles, and everybody has historically talked about making sure you have good coverage, maybe up to 10 times coverage of what you invest in terms of what's likely to be available in terms of damages that flow from the case. And I don't think that changes, because budgets do increase in the same way they do in other jurisdictions, and quantum can reduce as the case goes on, particularly for settlement. So that's pretty much, it's the same principles. Most of the firms that are operating in those courts, the DIFC and ADGM, and in the construction disputes in DIAC, or what was there before it, are international firms. They're well versed in budgeting. They understand the adverse cost regime, and I would say in terms of quantum, yes, there are smaller value claims. Some of the DIAC stuff that we've been doing recently isn't huge quantum, and maybe the budgets are sort of $750,000 to $1 million. But that doesn't mean they can't be funded, as long as you have the right ratio and the damages in dispute are sufficient to ensure that the client at the end of the day is going to get an appropriate sum and the fund is covered. So the rules don't change. And I think one of the benefits of this region is a lot of the firms that operate here are international. They're well exposed to funding in Europe, in the UK, and in the US. They understand how it works. They've probably done funded cases in different jurisdictions. And actually, it's just an extension of their practice, what they've done before. And so actually, there's quite a lot of experience, and the market is maturing. The understanding here of more of the local practitioners as well as the international practitioners is growing. And, as I said, it's been 15 years since it first started, and the likes of Ahmed and DLA and his colleagues have been doing a lot of funded work out here. So the word gets spread, and it's becoming very much more mainstream. I don't think we're quite there yet, but the principles apply here in the same way that they apply in any other jurisdiction.
Okay, Kishore, just occurred to me. So you are on the funding side. You arrange and it's financial instruments and funding for to enforce, funding to conduct litigation. Are you finding that there is an education here that local investor, even investors from outside the region, will look at local litigation more? It occurs to me that if it's a lower cost and you can factor into the economics that you're not going to get costs back, then it's almost, and I think there are obviously fixed court fees, and I think advocates, common law, we would say, it's like a barrister. A barrister charges a brief fee. It's fixed. You know what it is. Advocates charge fixed fees. Ahmed touched upon it. It's first instance appeal, cassation, etc. Given those economics, in your experience, do you see more funders willing to look at the local civil court cases? And is that happening?
Well, I will say, Jonathan, that the legal landscape across the Middle East is evolving quite rapidly, and the international law firms remain prominent in terms of taking the high-risk cases, and particularly involving cross-border disputes and complex litigations. Local firms, they are highly focused on the local matters. Okay, so for the funders, they want to see where is the case. Okay, what's the jurisdiction, size, complexity. Okay, so I will say that local firms on the onshore litigation are dominant. Okay, so the local law firms are often first choice for the litigation on the onshore court.
And are you saying are you seeing those being funded now? Is there any funding? Any financing going into local cases, or that's something we're going to start to see moving forward?
Yeah, it's happening.
It's happening.
It's happening, but these are like, they need to see they are very conscious and cautious about investing into the cases having local jurisdiction rather than offshore, which is DIFC, ADGM. Okay?
And the finances going into those local cases, would they be local funders, maybe family offices who are being educated by people like yourself that it's
exactly
okay.
Exactly. In terms of education, there's a lot to provide awareness, I will say, in the region. Many lawyers, I find that they even don't know the litigation funding is a concept or asset class or the facility is available in this region. They only know it's in the US. So, and sometimes some of the lawyers, they don't even know what is this. So I need to explain everyone that this is how it is.
Yeah.
Okay.
And that's right. And to me, if the litigation funding industry there are obviously funders here, but if and European funders more than American, but if the US funders had an appetite for here, there are some burgeoning markets. Saudi is a burgeoning market, UAE obviously. So I think there is a big market for litigation funding in the Middle East.
It is, yeah. And then regulations are accepting litigation funding, okay? But the practice is still an issue, okay? Now let's talk about this local versus international firms. What is the trend, okay?
Yeah.
So I will say there is a growing influence of a regional powerhouse, like big firms like Al-Tamimi, Hadif and Partners. They work like a regional giants, okay? They have a good expertise which includes mix of local and international expertise. And these firms bridge the gap. Purely local practice with the larger international firm, they have tie-up and they have a good team. So this is how it's happened at the big firm level. International firms, they are leading on offshore and complex arbitration cases, like dispute on the offshore jurisdiction like DIFC, ADGM, and those involving the international platforms like ICC, LCIA. They often require expertise of international firms like Clifford Chance, Baker McKinsey, Allen Overy, these kind of firms.
DLA Piper.
DLA Piper, of course. Yeah. So because they are well equipped and their ability is developed to handle the complex cross-border matters, large-scale documentary discovery, sophisticated financial analysis. So they are well equipped for managing those things. We also have observed, let's say, a shift towards a hybrid model. Okay, there are hybrid models we have observed where international firms often collaborate with the local firms.
Yeah.
Okay. And on the other hand, we have seen that the local firms have kind of a cost efficiency and cost advantage, and they are better equipped with navigate bureaucratic process here locally and establish relationship with the government authorities, for example. So they take advantage in those areas. Like, for example, we have seen one case in Oman, which is $5 million case for employment dispute. And this case was settled at approximately 1/3 cost of any international firm.
Yeah.
So this is like depends. Yeah, this is what's happening. So, and there's another factor I would like to mention, that there's increased sophistication of local tenant happening. Like many big law firms in Middle East, they get legal training from international places like UK, US, Europe, and then they become well equipped and they can handle high value disputes. And then they compete with the other international law firms. So this is very much Dubai. See, especially Dubai and UAE is kind of a center of legal kind of areas, you can say, like after DIFC and ADGM is there, plus the DIAC also there. They are focusing to create an international platform, and they are successfully managing the international disputes to resolve and bring the cases here to resolve.
I agree, Kishore. I agree. And the international firms have been here in various guises since the late 1980s, early 1990s. And then when DIFC set up, obviously there was a ground rush of international firms into DIFC. So that leads me to a slightly different perspective, which is in I guess common law jurisdictions, but other jurisdictions around the world, there are public records. There is availability of records. There are mechanisms. There are common law mechanisms by which to get disclosure, early disclosure. In America, there is pre-litigation depositions and disclosure, as I understand it. Nick, if I maybe put that to you, my understanding is it does differ in the Middle East. Certainly in the civil law jurisdictions, it does differ in terms of being able to access information about your counterparty. If you are funding a claimant against a defendant, is it a strong defendant? Does it have the ability to pay? So what kind of mechanisms are available to make that determination?
Yeah, it's a little different here, and it's slightly more nuanced. If you're in a large construction dispute against a multinational respondent or defendant, then clearly that's a bit easier, and that tends to be the targets that funders identify and tend to go for. If it's a slightly lesser known respondent, a local defendant, that's a bit more challenging. I mean, there isn't an open source company's house. There's not necessarily an obligation to file accounts, and it's pretty difficult to find out from a smaller business or a more local business what the assets are, who the owners are, who your actual opponent is. And that's something that you have to take into account here and be a little bit more careful of than perhaps you would be in other jurisdictions. So assessing the collection risk can be a challenge, and that's probably why, or certainly why, in fact, in the DIFC, where you do have the ability to do a little bit more rigorous assessment, and in ADGM, and in the larger disputes, the construction disputes, where you know who your opponent is, they're more likely to be funded. There are nuances in other areas, not just collection risk. For example, there are certain issues in relation to challenges that a defendant might throw at you even after you've won an arbitration on enforcement as to whether or not the party agreeing to bind that party to an arbitral clause is something which they should or shouldn't have done. And I've seen that as a challenge over the years.
We're going to be asking Ahmed exactly about that.
I'll let the DLA experts talk about that.
Just a moment.
So the underwriting can be nuanced here. Collection risk can be an issue, and that is one of the challenges here. And there isn't an easy way around it, other than, as I say, and even with the large international firms, in terms of defendants, there are challenges because they can be local SPVs, they might be some sort of joint venture, and you do have to be careful. Firstly, that you're dealing with who you think you are, and do as much research as you can, albeit it can be challenging.
And something a little bit left field is that Ahmed, number one is that my experience is that final binding monetary awards in the UAE are now readily being enforced, for example, in the UK, and final binding monetary awards in the UK are being enforced in the UAE. Now, the second way, coming from the UK or other countries to the UAE, one might first of all go into the DIFC and seek the enforcement there, and then take that final award to the local civil courts to get the enforcement process. I've seen more of that. Are you experiencing that? Because that's important for funders to understand.
Yeah, they call it, I mean, it's been termed over time the conduit jurisdiction route. In Dubai, it's kind of gone up and down a little bit and caused a little bit of tension between the DIFC courts and the Dubai courts and their sister courts as such. They kind of have a mechanism, it's a law, it's a Dubai law, an onshore Dubai law that says they must recognize each other's judgments and just deal with them. So if a DIFC court has recognized a foreign judgment and said this is fine with me, it should go onshore without any problems in principle. While parties were doing that, it triggered, I think, a discomfort with the Dubai courts that their jurisdiction was being seized in circumstances where they were being circumvented, because that's what was ultimately happening. Rather than applying the onshore rules to enforce a foreign judgment where that's where you wanted to ultimately enforce, you're going to another court that you thought would be more favorable. Now, that led to a committee being formed to deal with disputes of jurisdiction between these two entities. And over time, the view has changed because the composition of that entity has changed. Currently, where we are at is that the conduit route is kind of okay, and they will allow it to happen. A few years ago, that wasn't the case. But it's controversial to the extent that the ADGM and the onshore Abu Dhabi courts, who also have this kind of mechanism between them, have formally legislated that conduit out. So we can't say with certainty if it's here to stay.
Yeah, no, understood. Totally, I have experience of going the other way. A UAE final binding, unappealable judgment back to the UK, enforced in the UK courts against UK assets, enforcement freezing orders and that kind of thing. And ultimately, getting a judgment and getting a return. And I think the defendant was rather shocked because I thought he thought he was ring fenced in the UAE and his UK assets were absolutely. So the defendant, he or she, can't say what that is, thought that they were ring fenced and they couldn't. They were impenetrable. But as it happened, they weren't. The UK courts were very robust in their approach. But my understanding, it has to be final, unappealable, and for a monetary judgment to be able to be enforced. But also, Nick touched on one of the which causes some controversy. Number one is that, now I'm going to try and explain this right, is that if one enters into a contract, a construction contract or any form of contract as an arbitration clause, the other clauses in the contract do bind the counterparties, but the local courts here have historically found that unless there is specific powers granted to the signatory to bind the company to arbitration, then the company that signed the contract can actually reject the arbitration on the basis that they accept the contract, but they don't accept the clause. Could you tell us a little bit about that?
Yeah, so it comes from the historically restrictive approach, at least in the UAE, in terms of special kind of authorizations that were required for certain kinds of legal entities to enter into arbitration. That kind of advanced a little bit now, especially with the new arbitration law. the advancement of the arbitration rules, at least of the institutions here. And the position generally is now, if you don't raise your jurisdictional challenge of any kind in the arbitration, whether it's the authority to enter into the agreement, whether it's the tribunal, whatever it might be, you're very likely going to have these kinds of challenges dismissed on enforcement. So it is either you deal with it in the arbitration. If you're not happy with the result, you take that to the court immediately. If not, the outcomes are certainly not going to be weighing in your favor. So I think historically, yes, I think this is something that you would be quite worried about. But I think nowadays, you still, I think, would take all of the necessary precautions when you're, at the outset of the arbitration or entering into the contract to make sure the relevant authorizations are in place. But you would also want to make sure that if there was a jurisdictional challenge, it would be dealt with pretty much at the outset, so it could just be dispensed with. So you're not dealing with it on enforcement. I think important, it's kind of like a non sequitur here, but it's kind of related to the power of attorney point. And it's related to how you structure your litigation funding, where you want to kind of take over an arbitration. The assignability of arbitration clauses remains a big question in most of the jurisdictions, including the UAE. So if you wanted to assign an arbitration clause for somebody else to run the arbitration on a third party, that would likely be very difficult without consent of all of the parties involved.
Yeah, no, understood. It's important. People would be interested in the power of the power of attorney here. So if you run an organization, I think there is assumed signatory rights, assumed power to bind a company in other common law jurisdictions. And there is here to a certain extent, but to some extent, you would have to, you could challenge the authority of the individual who signed the contract on the basis that he or she didn't have the power of attorney in place. Now, to my experience, power of attorneys are absolutely key here. So any counterparties doing business here or entering into contractual relations or litigating those contractual relations, they probably would have to demonstrate that each party had the requisite power of attorney signed at the notary, which empowered the individuals to sign and bind those companies, which is kind of a stretch from common law. Common law would normally have assumed rights of executives, purported rights. So that's a differentiator. Kishore, sorry, I've got another question for you. So in the civil courts here, when the parties seek to enforce arbitration, do you find the local courts are now being consistent in their approach, or are there still some inconsistencies? I say that because for the people who aren't necessarily aware, the civil courts do not necessarily adopt a process of precedent, so they can't simply cookie cut from a previous application. Are the local courts being loyal to the spirit of the arbitration, or do you still find it inconsistent?
Well, I will say quite challenging. Asset recovery in the Middle East presents both kind of opportunity and challenge, I will say. And this is due to different enforcement practice, legal framework, cultural nuances. Even after securing a favorable judgment or arbitration award, collection enforcement can be very complex, I will say. Okay, so in recognizing the foreign arbitration award, many times we have seen challenges. Like if you see, while most of the GCC countries are signatories to the New York Convention,
Yeah.
however, then the practical challenges enforcing the award. Okay, especially when courts like prioritizing local public policy consideration. Okay, sometimes some jurisdiction may require translation and significant additional papers that delays the whole process also. And courts are quite resistant to be a pro-national stance, and maybe they might sometimes give favor to the domestic party over the foreign creditors. And there are collection issue over the above. There are collection issue also, like asset transparency is an issue. There is a limited public database available for the asset ownership, property, bank account, complex holding structure. Many times there are family-owned businesses and they have a diversified structure. They try to hide as much as possible. Often they have like an interwoven financial structure, making asset tracing highly difficult intentionally, for example, sometimes.
Yeah.
And there are legal restrictions, like some jurisdiction, they limit the access to financial information during the enforcement. So, like I'll give you example of like Qatar. Even if you have the court decision, they won't give you financial information. The banks will not give you financial information.
So
We have seen the cases.
even if the court, because I know in other civil jurisdictions, if the court writes to the bank is obligated to provide the information. Whether it's slowly or quickly is another thing.
I'm going to come on this how, because we have seen DIFC and ADGM are playing a very good role on this, but let's talk about the other Middle East areas, like other jurisdiction where we are facing challenges. So like another challenge is like a local court attachment, freezing assets. Okay. The procedures to freezing assets in many require extensive jurisdiction, like someone granted only after lengthy court process. Okay. So it's not like easy, straightforward like we have in the common law basis. The court may be reluctant to order a freezing order, measuring against political connected. You see that some people are politically connected and the state-owned entities. Against them, court are very conscious about, very reluctant to release the freezing orders. On the contrary, sometimes we have a temporary retrenchment, short term, and that may expire quickly because of this swift legal action to be followed on those cases. And over and above, especially in the Middle East, we have cultural issues, cultural and bureaucratic factors. So there are so many kind of relationship basis, and trust plays a crucial role in the negotiation and settlement and recovery and bureaucratic delays. So these are the things. So in order for us to, for any litigation funder to overcome or to face the challenges, the idea is that we should have enhanced due diligence both within the region and abroad, and we should partner. They should partner with the asset tracing experts so that they can help them better in terms of local expertise. We can take always preemptive freezing orders, and especially offshore court, DIFC, ADGM are more likely to grant asset freezing orders faster, efficiently in comparison to the local courts. We have use of we should better use of offshore court rather than onshore. Then negotiation and settlement.
You're applying. I know what you're saying. You're applying common law principles for early pressure. So you're applying.
Yeah, exactly. To be more proactive, to focus on how to take a preemptive actions.
Thanks, Kishore. Thank you for that. So, Obaid, hello. I will be asking you a question very soon, so prepare yourself.
Sure.
Nick, so my understanding is the DIFC and the ADGM, they are the two English-speaking financial free zones we spoke of earlier. They have some fairly, I wouldn't say detailed, but at least they have some pejorative regulations they've created about funding. Are they anodyne? Are they funding friendly? Are they quite detailed? How do they look between the two free zones?
They're based primarily on what's been done in other jurisdictions, I think. The DIFC practice notice is 2017, and it gives an indication that if you have a funded case, you need to give notice to the other party, and it's something which a court can take into account when looking at the issue of security for costs. So fairly standard. The ADGM has a set of rules which come from, I think, the 2019. They have the same notice provision. They're a little bit more akin to maybe the Association of Litigation Funders Code of Conduct in the UK or in England and Wales in relation to English commercial litigation. So there's a provision that a funder has to, there's an issue in relation to conflicts, a question about conflicts. There's a question that requires you to be a professional funder that has creditworthiness of up to $5 million US or equivalent currency. The funding agreement has to be reduced to writing in terms of the amount of funding, what the funder's recovery is, the funder's involvement in settlement, again, very much like the ALF code in the UK, and also in relation to termination. So I think the good thing is that it's been addressed. I think the funding is very much accepted and understood, and I wouldn't go as far as to say encouraged, but certainly something which is in the mind of both the ADGM and the DIFC courts, and something which is being done fairly regularly in the DIFC. I've not seen so many cases in the ADGM, and obviously it's not every case, and it's not prevalent in those offshore jurisdictions here, but it is something which is considered quite regularly. So it's appropriate that both courts have considered it and have at least rules dealing with the basics of conflict and things that you need to notify to your opponent. So yeah, it's a positive.
Okay, good. Obaid, question for you. Two questions, two parts to this question. First of all, and it's great to see you. First of all, so in the common law jurisdictions, DIFC and ADGM, Nick has told us that there are written regulations. The regulators have recognized litigation funding and its need. My first question to you is, in the local civil jurisdictions, we call them the onshore courts in the UAE, have any progress been made to having those courts formally recognize funding? How would you fund a local case? And who funds it? Is it international funders? Is it local investors? So those are I guess there's two questions.
Thank you very much. First of all, sorry for because the email was saying that it's 6 o'clock, not 5 o'clock at Dubai time. This is why I joined late.
That's okay, Obaid. We are an international audience. I think there are people here from all over the world, so it's not a problem.
Okay. So just I would like to actually make a distinction here between the onshore court and offshore courts on the ground that each court has its own rules and regulations. So, and that governs the cases which is funded under that regulations. So despite the fact that onshore, actually, we don't have to regulate, or they don't have to regulate third party as on today. So they don't actually contain any provisions which prohibit the funding by third parties. So I used to do it for the last 15 years, and the contract regulates the parties' relationship. So if you are funding in the local market, in the onshore courts, so the contract regulates the relationship. So we didn't face any problems since there is no regulation on that issue. However, on the offshore, yes, as Nick said, ADGM and DIFC, they have their own regulations, and they have certain conditions. You have to disclose the agreement. You have to disclose that you inform the second parties, the opponent parties. So all these things you have to comply with. Otherwise, you might lose to execute that contract. So that's
okay. Well, that's interesting. So if a funding contract in the local Arabic courts was to be challenged, then your analysis is the court would uphold the terms of the contract.
Definitely.
That's very interesting. That should actually be encouraging for third-party funders from outside of the region, because it's we've touched upon already that local civil litigation is less expensive, and can be quicker. I'm about to ask Ahmed that question, and is probably more straightforward, and is very much, there is less advocacy, there is no oral cross-examination of witnesses, so it could actually be a real boon for funders. It could be a real sort of comfortable space for funders if they understand more about it. So Ahmed, you have a foot in both camps. So you do common law international and you do local. Generally, which is quicker, which is easier, which is consistent, which is inconsistent? Sorry for all the questions.
No, not at all. I think there was a time I would have said one might be faster than the other, or one might be more cost effective than the other. But I think the reality is, I think especially in jurisdictions like the UAE, that, I mean, every year are becoming extremely more sophisticated and equipped to deal with the kinds of cases they're dealing with. There's a lot more scrutiny and time spent on onshore cases, you know. And it's not necessarily just the expert processes that you kind of have in between. It is the amount of time that is, I think, spent on submissions and the amount of time that are spent considering the judgments. So I think really net, let's say you have, a standard construction dispute with the standard construction claims coming out of an arbitration or an offshore proceeding from start to finish. You would probably come out on the timeline wise, at least on an onshore dispute from, the court of first instance all the way to the court of cassation. So I wouldn't say that there is that much of a difference. Obviously, you would be running your arguments differently, making your submissions differently, but the time element of it is more or less the same now. So if that was a determining factor in the past, I wouldn't say that it's one now. But obviously, Obaid might also disagree with me.
I would disagree definitely because.
Good, thank you, Obaid. Good. Let's hear why you disagree, Obaid.
It depends on the market you are in. So if you take, for example, in UAE, the courts are very fast in passing judgments. So it's almost as good as the arbitration in the DIFC or ADGM. So compared to other countries. So as a litigation funders, I don't.
Obaid, sorry, I just need one house. Kishore, could you mute yourself, Kishore? Could you mute yourself? Brilliant, thank you. Continue, Obaid, apologies.
Yeah, so, and also the advantage in the onshore, the fees are capped. So for the litigation funders, actually it's more advantage even to compete with, if you get any competition in the market. It's better for me to go on the onshore rather than going on offshore courts because of the cost.
Obaid, there's a famous legal saying, I am also drinking your Kool-Aid, because I do think that local Arabic litigation is infinitely better. I don't want to be controversial than it was 15, 20 years ago. I think it's infinitely clearer. And I do think it now is creating some fair results. There are some examples. Ahmed, also, Obaid, this is an interesting one for you. So arbitration agreements, costs award are given by arbitrators, and they could be huge, substantial amounts of money. And I know that more recently, the local courts might say, well, you can have your arbitration award, but we're not going to award your costs because that's not what we do. We're civil. But I think that's changing. I think the courts are now honoring even large costs award ordered by arbitrators. Is that right?
Yes, you're right. Actually, if the parties agreed to for the arbitral tribunal to allocate cost based on that agreement, the court will decide. But if there is no agreement between the parties to accept from the beginning the cost, they might actually cap it from the judge point of view. But if there is usually, especially now, because of the previous cases, now the arbitral tribunal requesting the legal counsels to get the parties' approval on the cost. So when it goes to the court, the court has to comply with the agreed what the parties agreed on. So now it's actually they are complying with the parties' agreements.
Yeah. That's interesting. John, I think we are at a time when I'm informed that we're going to start to wrap up. Is that right? If you're going to pop back in the room. One more question. Oh, John is popping back in the room, but we have time for one more question. Okay, Nick, I have a final question for you. Actually, no, I have a final question for everybody. The feeling I'm getting is that as lawyers, being myself, being Obaid and Ahmed, we are seeing both court systems here, the Arabic civil system and the English offshore system, common law system, embracing funding, giving clear parameters to funders, or as clear as can be given, and giving great opportunity to funders. And perhaps the Arabic system has been playing catch up, but I think it is now almost there. Now, Kishore and Nick, from your perspective, Nick, if I can ask you, going forward, Do you see more funders looking at the Middle East? Do they have an appetite? Will they embrace the Arabic system? Will they work it into their economics? And do you think the Middle East is a growth area for funding?
To deal with the last bit first, it's certainly a growth area for funding. The direction of travel is only one way. Funders are here more regularly. Arbitration week in November, there are a lot of funders here. There are at least 3 international funders based here permanently. And not just Dubai, Abu Dhabi, the UAE. There's funding going on in Oman and Qatar. There are things happening in Saudi. And obviously there's the NPL, non-performing loan bank debt, which is a significant part of funders' interest here. So I think, though, to your point in relation to local courts, that will take a bit longer. I think the language barrier is more of a challenge. I think there's still a reticence from the more international funders, but it's certainly, Obaid is a prime example of more local funders embracing that, dealing with the direction of travel again in the right direction, and embracing funding generally. So it's certainly becoming something which is happening more often. It will take a little bit longer for the international funders to become more comfortable, but that gives an opportunity to the local funders to really establish themselves and make hay while the sun shines. So I think it's a positive thing.
Obaid, sorry, we're still on the same question, John. Don't cut us off. Obaid, are local funders really starting to understand the asset class? Are there local Emirati, Saudi, GCC investors and families coming into this asset?
Yes, actually, there is a good demand on litigation funding, because see, the Middle East present an immense opportunities for litigation funding. But success require an understanding of the region dynamics, the regional dynamics, and diligence of the cases, selected cases, and regulatory compliance. So, and definitely you need also to use an advanced technology to unlock, is essential to unlock this potential. So, because you see, if you need to enforce a judgment on a cross-border, definitely you need to have a technology to trace these assets if you want. It's not easy. There is a difficulties. There are certain challenges, but there is a good demand.
That's great.
I will add a little on this, Obaid. Thank you very much, Obaid. On the other perspective, from the liquidity point of view, we see unfortunate, UK and Europe market is kind of drying up. Liquidity is abundance in the Middle East. Middle East investors of various class investors, they are always looking for the new kind of investment or asset class. And recently they have very much recognized this asset class, litigation funding as an asset class, very well. But they are keep on looking how to develop this, how to structure this. The expertise are limited in this region. And we see a very, very good scope going forward, developing a well-structured litigation funding market here in the Middle East.
Thank you, Kishore. Yes, I agree with you, but I think the market needs more awareness. Even parties, even not only leave the parties, actually the lawyers themselves in the market, they don't understand what's litigation.
Of course, I think, Obaid, you just joined recently. In the beginning, I already said the same thing, that a lot of awareness required, and we also plan to do something dedicated awareness campaign. And I said the same thing. So many big lawyers, even they don't know this because they have never come across this kind of proposition. And lawyers are not finance people. So they don't focus on this unless you give them a proposition and they come across this kind of situation. And believe me, they have many cases. And the moment they come to know litigation funding available, they always want to, oh yes, I want to do this. Always. So
Kishore, what
appetite
about...
is there, liquidity is there. I'm saying appetite is there, liquidity is there. The resources are required. The market is ready.
What about if we do a legal funding journal conference in the Middle East next year, and we ask John and his team to put that together for us? Would that work, John?
That works on my. I love being volunteered for. That's fantastic.
Lovely.
How are we doing? How are we doing for time, John?
We're right at the top of the hour, so that'll have to do it. We really appreciate this, everyone. Just a really terrific conversation on, as I said, a topic that needs more awareness on funding in the Middle East. So thank you all, and I want to thank everyone for attending today's event. Special thanks to our moderator, of course, Jonathan Davidson, and our esteemed panelists, Nick Rolls-Davies, Ahmed Hamadi, Kishore Jaishandani, and Obaid Mashar. Thank you all very much. Really wonderful discussion. As a reminder to everyone, you will all receive a link to a recording of the event within the next day or so. Please stay tuned for that email. We'll also be convening our community at the next virtual town hall next month, so details will follow. So stay tuned for that as well. And of course, for details on becoming a Legal Funding Journal member, please visit us at our website, www.legalfundingjournal.com. Thank you again. Take care.
Thank you.
See you at the next one.
Thank you, Jonathan. Thank you, everyone.
Thank you, everybody.